Okay. All right, great, guys. Welcome. I am Corey Silverstein. I drew the small straw today, so I get the pleasure of moderating my colleagues and my dear friends here. We're going to take a second to do introductions. I'm Corey Silverstein, my adult attorney. I've been an industry lawyer for about 15 years or something of that nature. I practice all areas of the adult entertainment industry. Doesn't really matter what facet you're in. Pleasure to be here, and really looking forward to working with this group. And of course, just real quick, a special shout out, Reed. We lost our friend Joe Obenberger, and I know you and Joe were especially close. And so my condolences, Reed. I know you were hurting, and thank you for being here. Jeff, who are you?
My name is Jeffrey Douglas. I'm a criminal defense attorney in Santa Monica, California. I've been representing the adult industry solely from the perspective of a criminal defense attorney since abacuses were new, 1981, I guess, or something. So I don't write contracts. I try to avoid reading them. I've advised every component of the adult industry regarding risk assessment, and continue to do so. I also am honored to be the chair of the Free Speech Coalition, the industry's trade association, since 1995 or so.
Hey, you were close. It's good. It's all right. Reed, say hello.
My name is Reed Lee. I'm practicing attorney, living in Chicago, working out of Chicago. I have been practicing law for about 35 years, all of it primarily devoted to protecting free expression interests. The adult entertainment industry has, of course, been a big part of that all along.
Thanks, Reed.
I'm Lawrence Walters, Walters Law Group. Practice out of Florida, represent clients worldwide in connection with the adult entertainment industry. Website's firstamendment.com. What else can I tell you? I've been doing this for over 30 years. I'm the general counsel for the Woodhull Freedom Foundation, which is a sexual freedom organization that helps defend sexual freedom rights throughout the world. And been representing primarily internet-oriented clients in the adult entertainment industry for the last 20 years.
Thanks, Larry, and thank all four of you again for being, well, for three of you and me. I'm going to tap myself on the back. All right, guys, we have obviously a very exciting thing we got to talk about today. We've got the big elephant in the room. The whole industry's talking about it. Everybody wants to know what the hell is going on. We've got a new United States president coming into power. Joe Biden has, well, we'll say seemingly won the election for the minute, and assuming all of these whatever goes away and he does take office, what does this mean for the adult entertainment industry? And you know, I'd love to get everyone's thoughts on the subject. Are we talking about a monumental move here? Are we talking about earth-shattering changes to the legal landscape of the adult industry? So Reed, why don't we start with you, if you don't mind, and love to get your thoughts.
Well, in this context, we ought not to forget the vice president-elect, who is, as far as I recall, alone among major party candidates having suggested decriminalization of sex work. I do not expect she's going to be waving that banner vigorously at the beginning, but there are opportunities there that are opening up too that are very interesting. In general, I think we're going to see a return to some sanity. The Justice Department will not swing dramatically in terms of its operations, because it has been operating pretty much the way it has for a long time through different administrations. Trump's efforts to change that, I predict, will not last. We return to a Justice Department that, on the criminal side, prosecutes vigorously when it decides to prosecute. And I think something we're going to talk about here is a number of us are engaged in litigation against the United States over some important legislation. I don't expect dramatic changes from the Justice Department's perspective on their defense of Section 2257, but there are potential opportunities that we should certainly explore. In general, I do not expect that the Biden administration will be waving a lot of flags trying to take on the adult entertainment industry as an easy target.
Now, Jeff, you're out in California, and seemingly the Kamala Harris situation kind of came from your state, shall we say? So, since you're going to be our California voice of reason here today, do you agree with Reed, or do you think maybe we're going to see a little bit more action from Kamala? Are we going to see her trying to push some of her agenda items that we saw while she was a senator?
I agree with Reed pretty much in everything. I have a less optimistic view of Harris than he, because I saw her operate both as a district attorney and a attorney general before she became senator. But even if she were a committed advocate for decriminalization of commercial sexuality, there's no payoff for pushing that agenda within the Biden administration. So, it's noteworthy that obscenity prosecutions have been so incredibly rare for so long. Considering the literally countless, right? Not just the typical exaggeration or hyperbole of countless, but literally countless transactions that there are every second in adult commerce. There's a federal obscenity prosecution once every few years, if that, and that's just not going to change to the extent that there's not going to be a centralized federal action, but there hasn't been centralized federal action.
Since Reagan.
I don't know how long, but till the beginning of the Obama administration, which was really the end of Bush. So that's not going to get worse. I'm a little more optimistic, perhaps, than Reed, that we might be able to get some action on 2257 behind the scenes with the administration. Which is a reverse. I've normally been more pessimistic than he. We can talk about 2257 if time permits later. But I think that the areas of concern now are not very different than they were before. The areas that I suspect Larry is going to be talking about the end runs around the First Amendment, that there are forces that support in both state and federal government, masking it as being anti-sex trafficking, but much more realistically, just ways of trying to contain commercial sexuality. But by and large, the world of camming, the world of downloads, the world of all other transactions in pre-recorded material, that is going to continue to thrive and be safe.
Jeff, I agree with you. I'm in agreement with you with regard to Kamala Harris. I'm a little fearful of her, to be honest with you. And one of the biggest concerns I have in particular is Joe Biden's health, which none of us really know what it is. We can make assumptions and, we can play the Monday morning quarterback all day long. But the fact is that he is in his late 70s. There is a question as to what his health is, and that puts Kamala Harris very close to the big seat. So I actually agree with you, Jeff, and I tend to be a little bit scared, to be honest with you. And I'm very hopeful that Biden stays healthy for these 4 years, because I have some serious concerns about a potential President Harris.
Well, the only time that you see aggressive action against the adult industry from the federal side is with a Republican administration, because it's not like there are victims. It's not like there is a the typical external forces that push law enforcement. It has to come from both true ideology and a political payoff. And however ideological you're likely to find someone who runs as a Democrat, they're not going to be as ideological as an Ashcroft who believed that he was risking his immortal soul because out there were people masturbating and he wasn't doing enough to stop it. Those kinds of crazies are not going to be in a Democratic administration. And there's no political payoff. It's not like there's a meaningful constituency that is going to, vote against someone in a primary because they're not strong enough anti-porn. So whatever her, so the adult industry is just not going to be a factor in any Democratic administration. Definitely not Biden's. That is pretty safe bet. And I can't imagine it would be in Harris, especially if she were to become president following the disability or death of a president. But there's no more tenuous role than a person can be in. They're not going to strike out on anything. They're going to be very conservative in the traditional sense of the word. That is, they're not going to take on any new and exciting anything. They're just going to follow.
So, Larry, I don't mean to throw you under the bus here. A lot of really good points have already been made, and really good, frankly, debate topics. Now, Larry, where I want to kind of push you in terms of the question I originally asked about Joe Biden is obviously, and we're already seeing it here on the right screen, Alexis Taylor and a few others are asking a lot of questions about Section 230. This is very unique, Larry, because this time we've got a outgoing president who seemingly is, pretty much out of control and doing whatever he wants for the next month, who doesn't like Section 230. And we have Joe Biden coming in who doesn't like Section 230, or at least wants it changed for that matter. So, Larry, you're obviously involved in the FOSTA-SESTA challenge, which is one of the heaviest ongoing constitutional challenges we already have. Larry, where do you see this going with Section 230 and our new incoming president?
Well, there's efforts to try to reform Section 230 on both ends of the political spectrum for different reasons. It's really a bipartisan effort, but there's different motivating forces. I have real concerns with Kamala Harris coming in, both as vice president and as president. Even if Joe Biden remains in good health, I think that she'll play a more active role than the traditional vice president in office. And I think that she will have the president's ear, that she'll push some of the policies that she wants to see happen during his administration. And one of those is likely going to be, the effort to try to bring justice to sex trafficking victims and heavy enforcement of sex trafficking laws. We shouldn't forget that Ms. Harris pursued Backpage when she was Attorney General in California very aggressively, ran into Section 230 problems with that prosecution, and is therefore no friend of Section 230. And remember, Section 230 is one of the primary protections that online platforms, including adult online platforms, have against many different types of civil claims as well as state level prosecution. So, we could end up with a fight to reform or eliminate Section 230. We saw it already with FOSTA-SESTA, and I think that there were some lessons learned by the government as to how effective it can be to eliminate certain unwanted content by amending Section 230. And we see 22 different proposals on the table now to reform, amend, eliminate various protections or provisions of Section 230. And I think that the Harris-Biden administration will be all in on that. And it could even happen before the end of the Trump administration. There's some hearings going on now with the Defense Authorization Act and some efforts to reform Section 230 even under the Trump administration. So it's something that we have to watch closely in the short term and in the long term as the next administration comes into office.
Reed,
and yet the focus of the efforts relating to Section 230 has changed very, very dramatically. And Larry, you're correct in saying it has split and splintered into many different forms. The pending bills, a few of them concern drug sales on the internet, but most of them are now focusing on moderation policies. A very different focus than the onslaught against Section 230, which for years focused on sex trafficking and third-party advertising of prostitution. And this new focus opens up, I think, very different questions that require, a different kind of analysis, and require us ultimately to think about the extent to which Section 230 does anything more than states what the First Amendment requires anyway.
Yeah, I think that's a good point. Some of these proposals could impact provisions other than the moderation and Good Samaritan provisions, which is what you're referring to. You've got like the Earn It Act and the PACT Act to a certain extent. Broader authority to prosecute online platforms by state agencies, state attorney generals, the FTC, FCC. And so, we'll have to see what gets legs, what gets traction in Congress, and what they can end up passing. But it's a time where, the assumption that platforms are protected with respect to the content that third parties upload is no longer a given. And either through, some sort of executive action, through FCC rulemaking or legislation, I think we're going to have a different environment coming up.
Now, Reed, Larry and I oftentimes have this debate. Larry and I talk a lot about this, and I don't get as much time to talk to you in person as I do Larry. And Reed, one thing that we always talk about is we talk about that without Section 230, I think we can all agree the internet wouldn't be where it is today. I don't think the evolution of the internet would truly be in such a position, because who knows if companies like YouTube, Facebook, Twitter would be able to exist simply because of the litigation component. Reed, do you think that now that we've evolved, and obviously Section 230 was created in a time long before YouTube and long before Facebook and Twitter, do you think that really kind of changes things now, that when all the politicians are looking back at it, they now have to kind of worry and think about these social media platforms when, frankly, originally they didn't even have to think about this?
Well, I agree that there are new concerns and new focus on the concerns. I understand the idea that Section 230 has been very important. I'm aware of, I happen to have with me a book entitled The 26 Words That Created the Internet, and those are Section 230C1, the protection against vicarious liability. Obviously that is critically important. Subsection C2, the protections for moderation policies that the interactive service providers adopt, critically important too. There's no question that the internet wouldn't be what it is without those protections. The very interesting question that I think requires a good deal of thought and prospectively some discussion is whether the First Amendment provides that protection, at least the protection against vicarious, actually both of the protection against vicarious liability and the protection of standards voluntarily adopted by those who control a communication channel. I think there's a very good argument that the First Amendment requires both, and so that merely repealing or substantially gutting Section 230 wouldn't do the job that the First Amendment provides those. But you raise a very interesting point about the new services available on the internet, new with respect to the adoption of 2257. And it gets to a point that I wanted to raise for thought. And that is that there are kind of paradigms that people have about communications, mass communication and communication channels. And I think they deeply affect what the expectations are and what the inclinations are for legislators when they consider changes in Section 230. And we might think of kind of a spectrum of those paradigms that a lot of people, when they think about the internet, especially the World Wide Web with moving pictures and sound as we have right now, recall the era of curated television, curated broadcast television. That is, the barriers to entry, the cost of production were very high. the channels were owned, very few channels were owned by very large corporations that were directly responsible for their content. And the content was advertising supported. And so the advertisers had their additional interest in moderating because they didn't want their products associated with smut or violence or any of the other filters. So I think one of the big problems that we have in saving Section 230 and its protections, or in arguing that the First Amendment provides those protections, is that a lot of legislators and a lot of people in this country think that the World Wide Web is like curated television and it ought to be moderated in the same way that was. We can move then on the spectrum to other models that are much less, make it much less obvious that the government should have some control and should limit the kind of moderation that the service providers are providing. And you can move on a spectrum from curated broadcast television to a magazine or a newspaper where there are editors and there may be zillions of articles. There may be one editorial policy controlling them. You move from that even further on the spectrum to the idea of a communication channel as a common carrier, where maybe almost anything goes, and maybe those who control the channel should have minimal control and minimal moderation. And there are important First Amendment interests, important free expression interests that are served by that kind. And then if you go all the way to the other end of the spectrum, you have the public square. And, the internet has often been talked about. The first major Supreme Court case, Justice O'Connor talked about a town crier heard round the world. That's the image that sometimes creeps in. And that is a very libertarian, very non-control, very anti-control, both by the government and as against those who are responsible for administering the channel. So we have this spectrum of kind of models, of paradigms that I think people are looking at. I think it's going to be important to develop arguments from each of those paradigms and assert which of them best protects the interest of those involved. We have lots of people in this presentation that are in control of channels. They want the protection for moderation control. We have other people that need a channel, don't have a channel they control, and they want maximum freedom on that channel, both as against the government and as against the channel operator.
So speaking of all this Section 230, Larry, now you're obviously intimately involved in the Woodhill Freedom Foundation's case to challenge FOSTA SESTA, which of course is one of the most brazen attacks that we have on Section 230 to date. I'm getting some direct messages here from people here that want to hear from you, Larry, as far as obviously we know there's been a lot of briefing and we know there's been some arguments, but Larry, where are we in terms of timing? Like what are we looking at here to start getting some questions answered in terms of what the court is going to decide?
Okay, yeah, sure. So here's the update on that. At the beginning of the year in January, we won the appeal, which essentially allowed us to go back to the trial court and make our arguments on the constitutionality of FOSTA SESTA. And then COVID happened, things slowed down a little bit, and the case finally got picked back up. There were some new DOJ lawyers assigned, and we have now filed our what are called cross motions for summary judgment, which basically means that each side is asking for judgment in their favor. Without a trial, we both decided, both the government and our side have decided there's no need for a trial. It would take a long time. We need answers now, and there's not really any facts in dispute. The law is what it is, and we know the constitutional arguments. Both sides agree on that. So we are now at the point of having submitted all of our briefs on these motions for summary judgment, and the ball is in the court's hand at this point. The court can render a ruling today or in 2 months or what have you, or more likely, the judge will probably set a hearing. It'll probably be a telephonic hearing, and the lawyers will make their best arguments based on what's been argued in the briefs. The judge will ask some questions, and then they'll sit down and draft a written opinion, and that will come out at some point. We hope soon. We've asked for an injunction. We asked for a preliminary injunction. This is the kind of thing that is generally treated as an urgent matter, but the case has been sitting around for a while, and COVID didn't do us any favors on the speed of the decision making. But we're hoping for something in the next few months, and it'll be obviously an important decision for the adult industry and for kind of the freedom of the internet itself. It will be educational to the government and to Congress as to what they can get away with, because as we've seen with lots of other efforts to modify Section 230, this is a test case as to what the government can do to try to take away Section 230, which is, I agree with Reed, kind of premised on First Amendment rights. Section 230 does a lot of the work that is already provided for by the First Amendment, but it also gives us something more. It gives us an immunity. It gives us a quick way out of lawsuits that would otherwise take potentially years of novel and complex constitutional arguments to try to deal with. It would increase the costs of being able to operate an online forum. It would scare a number of new companies out of the industry, and they would evaluate and say, we got to go litigate a constitutional case every time somebody brings a claim based on user content. We're just not going to bother with it. Section 230 gave that certainty to these companies, knowing that, hey, if somebody wants to file a frivolous lawsuit that's barred by Section 230, we file a motion, generally you get out. It's not going to be that expensive. It's going to be pretty quick. But with these constitutional arguments, as we see with Fosta Sesta, it can take years for a decision. So we're at the end of the road, hopefully, with the trial court case. The decision will probably be appealed to the DC Circuit again, and maybe up to the Supreme Court, but we're hopefully on our way to a decision here quickly.
And just for clarification, Larry, because someone actually just sent me a direct message saying, hey, I thought that the Fosta Sesta challenge was dismissed. And I think, Larry, there's a little bit of misunderstanding that people don't understand that the reason why the original dismissal came about was for a lack of standing argument, and it wasn't a decision on the merits. So could you kind of explain to our viewers here today exactly the difference between a procedural dismissal versus a dismissal on the actual merits of the case?
Sure. The important thing to understand is that the constitutionality of FOSTA has never been addressed by a court. The original dismissal was based on what's called standing, which is a legal argument that the plaintiffs did not have a sufficient stake in the outcome of the case, that they weren't sufficiently affected by the law to be able to bring a lawsuit. Under our system, just because you don't like a law doesn't mean you can challenge it in court. It has to impact you in some way adversely, and the court has to be able to remedy the situation with some sort of injunction in order for you to meet that initial test of standing. The court initially dismissed our case. We appealed it. The appellate court reversed the dismissal, reinstituted the case, and put us back to the trial court, the same judge that had originally dismissed the case, with instructions to say, you've got to consider the constitutionality of this law. These plaintiffs have standing. And so that preliminary issue is over. The case is not dismissed. It's pending. The challenge is ongoing, and we hope for a decision soon.
So Chloe Vartan, Larry, do you think, I want to get to Jeff because we've got an important question that's been asked for Jeff, but I want to quickly answer Chloe Vartan's question, who just posed to you, Larry, who says that she doesn't get the difference between Fosta Sesta and the Earn It Act. Obviously, two very different things. Larry, do you think you could give her the 30-second explanation?
Yeah, I can probably do it in less. Fosta Sesta is the law that was passed that changes Section 230 and does some other things like add a new federal prostitution law prohibiting prostitution using a computer service, and changes some of the definitions with sex trafficking to increase liability of online platforms. Fosta Sesta are two bills that were merged into one, so it's really just one law, but it was a combination of bills, which is why you have these two different acronyms. The Earn It Act is not a law yet. It's a bill, and it's pending. It's been changed a little bit since its initial incarnation, and it hasn't passed. It may not ever pass, but it's something that could change how the internet is regulated by appointing a committee to come up with internet regulation.
You did it, and you did it under 30 seconds. I'm impressed. So good job. All right, Jeff. I know you've been patiently quiet, and we've got some very important stuff to discuss because, Jeff, I've sat on a lot of these panels with you. All of us have actually. We've dined together, we've had drinks together, and we're all obviously very close, and we're all lawyer brethren, so to speak. Jeff, here's the most common question. Everybody knows that the Free Speech Coalition has been leading the charge in terms of fighting the constitutionality of Section 2257. The case has been going on now. The fight has been going on well over, I think, a decade now, and obviously it continues. And what we've done a lot, Jeff, during these panels is we've done the update. What's the update on the case? Where's the case at? And I think actually, Jeff, what we got to do a little bit differently this time, that a lot of the people that are here today want to know, is what is the future of this case? When is this going to end? How much longer is this going to go? And when are we really going to get an answer to the final question of, is 2257 sticking around or not?
I thought you were going to go Hitchhiker's Guide, the ultimate question of life, the universe, and everything. I was prepared.
I'm not quite that smart.
42. So, two separate things. Something that hasn't been mentioned yet, but I think is going to color things for at least the next couple of years. The Justice Department is in greater disarray than it has ever been before. The retirements, the infighting, the psychotic tenure of our current Attorney General, the once and future Barr, has really damaged things there. And a lot of the large policy questions, which normally have a relatively smooth transition from one administration to another, things are going to be different. I don't know how they're going to be different, but big policy questions about how to address these things, the people that were the institutionalists that made sure there was consistency and carryover, a lot of them are gone. And it's going to take the Justice Department a significant amount of time, years, a couple of years probably, to rebuild some of that institutional structure. There's a lot of momentum. Things just carry on. So anyone who's got a particular given case, whether it's 2257 or Sesta Fosta, we're not likely to see that change. But like I said, a lot of the big policy questions are going to be looked at anew, because there's going to be a lot of new policy people brought into justice to replace the people who have been fired or quit during the years of chaos. And as to your question of 2257, I can answer that simply, as most lawyers will answer questions like that. I don't know. But more narrowly, it is likely
I tried to put him in a corner. It didn't work. I tried, though.
It is likely that the government will petition for cert to the Supreme Court. The Free Speech Coalition will be putting in effort to negotiate both in the lobby and at the back door to prevent that from happening. If the Supreme Court takes up 2257, all bets are off. There is no smart money on that one. It could be they'll undermine a very important First Amendment case written by Clarence Thomas called Reed versus Town of Gilbert, Arizona, but which is the basis of the winning part of our 2257 case. So I don't know. There's just no telling. But there are a couple of practical things that can be taken away from the Third Circuit opinion, and that is the ability for the government to prosecute a 2257 violation has been severely damaged because the inspection regime violates the Fourth Amendment. That means how can the government know about your errors in 2257 record keeping? They can know it if they get a search warrant, not because they just walk up and say, so how screwed up are your 2257 records? That right is no longer exists. To get a search warrant, that means they have to have specific probable cause to believe that there's a record keeping violation. Now, I'm not talking about labeling violations, that's on its face, but record keeping violations, a thing that is not entirely within your control, unlike labeling, which is 100% within your control. Record keeping, for them to have probable cause, means essentially someone on the inside, an employee of yours, would have to find an FBI agent to say, my employer, has not just made a few mistakes, but is systematically violating 2257. Assuming that nightmare scenario happens, they'd have to find an FBI agent who gives a rat's ass, which is sort of hard to believe because there are not very many living people that give a rat's ass about 2257 these days.
Well, didn't we see,
not even the lawyers who are defending it?
But Jeff, didn't we see, I think it was last year, we saw a case down in Florida where they actually did tie in a 2257 charge into a larger overall prosecution?
That's different. If they have probable cause to get into your business because whatever, a claim of underage or obscenity or something else, or that you're a bookie den or something like that, if there's an independent reason to get in, then 2257 is fair game. But most businesses don't have search warrants executed on them, unlike any adult business being subject to an inspection. They weren't doing the inspections, which tells us a lot. But the likelihood of you having a 2257 prosecution over the last decade were incredibly small. Post Fourth Amendment, they become infinitely smaller. There are two reasons for you to continue to maintain outstanding 2257 records. One is it's still a law. You have to do it until the Supreme Court says you don't, you do, so do. But the second reason is because it increases the market value of your library. If you want to get an investor, if you want to sell, and someday you're going to want to sell. You're not going to want to do this until the day you die. Any potential buyer or investor is going to take any 2257 weakness that you have and lower the sales price, lower the value of your business. So by doing an excellent job maintaining 2257 records, you maintain the value of your library. That's a reason to do it, barring any fear of prosecution. And like I said, it's the law. The likelihood now, the nightmare scenarios that people dealt with in that brief period where there were 30 inspections in whatever it was, 2005, 2003, about, cross-referencing and stuff like that. That no longer is the boogeyman that it once was because of the elimination of the inspection regime, because it violates the Fourth Amendment. So that part's a big deal.
And which most people agree that it was ridiculous. The no search warrant was a little bit ridiculous from the very inception. But Reed, you wanted to add to it.
Well, yeah, I mean, there's something about the posture of this case that Jeffrey alluded to, but I think bears nailing down for the purposes of this discussion. That is that so far we have been to the last level, except the top level of the federal court, and we've substantially prevailed in the challenges to 2257. The Fourth Amendment victory is very important in the scheme of things. The First Amendment victories, where they are also important. Now, the next step, unless everybody agrees to let this Third Circuit decision stand, which is possible but would take some work, it's not the likely course. The next step is to ask the United States Supreme Court whether it wants to hear the case. Supreme Court doesn't have to hear cases like this, and usually it says no. The percentage of what are called certiorari petitions, cert petitions we've referred to them as, that are granted is very, very small. However, that percentage goes up very dramatically when a second-tier United States Court of Appeals has invalidated a federal statute. Then the Supreme Court has several concerns. One, their concern to give Congress its due comes all the way to the fore. And their concern about one appellate court, which has a geographical jurisdiction, in this case the Third Circuit is New Jersey and Pennsylvania, right? That one circuit says it's unconstitutional. What about the rest of the country? And so the Supreme Court seems to think, history shows that the Supreme Court thinks that the best reason for granting cert, or the best circumstances for granting a petition for certiorari, is when a federal statute's been declared unconstitutional by one or a few, but less than all of the courts of appeals. And they want to resolve that potential split in the circuits.
Well, I think we get.
Now,
I think we,
that raises the additional issue. The additional issue comes from the recent developments that we've all heard about on the Supreme Court. It is very interesting. It's more technically detailed than we have time to get into here. But the reason that the litigation on the First Amendment side has gone as well as it has goes back to this case, Reed versus the town of Gilbert, where Justice Thomas wrote the majority opinion that says if you have to look at the expression to determine whether the statute applies, then the statute is content-based. It is not content neutral, and it gets the most rigorous form of judicial review. When after Gilbert was decided, the courts that had been very skeptical of our First Amendment arguments against 2257 turned around entirely because of this new level of analysis that was applied. It will be very interesting to see what Justice Thomas does when this case gets there, because Justice Thomas had very little trouble using that analysis when it supported an itinerant church that needed to put up temporary signs. He's going to have a lot more trouble applying it to protect those who produce adult entertainment, sexually explicit adult entertainment. And what Justice Barrett will do now, I don't think she'll be friendly to this distinction from Reed versus Gilbert. Now, we'll have a fallback position. If Reed versus Gilbert falls, we've got a fallback position that says, even if this case is decided under intermediate scrutiny needs to be rigorous enough that this legislation is still invalid. But I'm afraid to say that Supreme Court review is probably the most likely course here, and it's going to be very tough to the extent that the only thing available to us is Reed versus Gilbert. That by the way, the Fourth Amendment issues are not subject to that. Those cautions are not problematic under Reed, and those victories so far seem pretty solid.
So, and Reed, that's all amazing information. And one thing that, of course, everyone who's here, for everyone who's listening today and watching this on YouTube later, we can't help but not mention the fact that the Supreme Court that we now have is very different than the U.S. Supreme Court that we had the last time the four of us got together for one of these panels. Obviously, a lot has changed. Trump's been able to appoint two new justices, and the balance of the court has most certainly been swayed. Obviously, we're going to have to see some of these justices in action, but something important to keep in mind. Now, there's so much. A lot of you are making some incredible points in the chat log, and I know myself, Larry, and Jeff we're doing our best to keep up with you guys with your questions. One thing that's very important for you guys to know, and we're always here for you. Reed, myself, Jeff, Larry, we're always here to answer your guys' questions. There's no such thing as a stupid legal question. Where the stupidity happens is where you try to make an assumption or you try to do something on your own without having the information as to what the status of the law is. And so don't ever be shy. I always make myself available, and I always will. I know Jeff and Reed and Larry do as well. And we're always, all of us are always happy. So please don't make the mistake of, if you don't know the answer to the question, just assuming that something is the right way to do, because truly it's a big mistake. Now,
and sorry to interrupt, but especially don't rely on a colleague to answer a legal question. And especially don't just rip off something else that someone is doing, stick your name on it, and assume that it will protect you. Yep. It will destroy you.
The stolen form legal form epidemic, as we call it around here, continues to be totally out of control, Jeff. And I, I see it all the time. I see people think, they even contact me and say, hey, can you just send me your standard form? There isn't a standard form. There are so many things that have to be analyzed when you're creating content. Where are you creating it? What sort of content are you creating? And Larry and I did a seminar yesterday, and one of the things that came up was that a form isn't supposed to be some document that just stays the same for eternity. A proper contract, a proper document that's going to protect you is going to evolve as the law changes, as cases come down, as we see, especially Jeff in your practice, you're obviously familiar, with all the criminal cases that come down, and you learn from those cases. And so the documents that are created, you can't just go and say, hey, I'm going to go and use that guy's form because, it worked 15 years ago. Well, I got to be honest with you. Go ahead and say that to, I hate to name names, but say that to the girls do porn guys right now. I believe that we just read some news yesterday. I think someone took a plea yesterday, Jeff. And so, there's been some action in that case, but guys, please, for the love of God, do not make the mistake of stealing other people's forms, or as Jeff pointed out, borrowing advice from a non-lawyer.
Yeah, and it goes even beyond, the forms is relying on what other people do as proper business practices. And we see that a lot, that, this other site or this other individual is doing it this way, and that's the way I've seen a lot of other people do it. A lot of people are violating the law, either intentionally or unintentionally, or they might have different risk tolerance than you, or they might live in a different jurisdiction, different elements that impact their legal analysis. So, what's right for one person may not be right for you, or all of them may be doing it wrong, and it's up to you to find out how to do it right.
Yeah, and that's spot on, Larry. And I don't know how many times all four of us have to say this over and over and over again. But anyway, all right, be that as it may, incredibly, we're already getting close to the end, and we're still getting questions. And again, I want to remind everyone that you can always contact any one of the four of us, and I'll, at the end of this, right before we sign off, everyone will go through and provide contact information. But real quick from each of you, and I'd love to just kind of hear in a kind of a 30-second or less answer, what do you see as now call it the biggest danger to the adult industry, and what's the biggest one that you think anyone getting into this industry should be on the lookout for, especially right now? So, Larry, why don't we start with you, and then we'll head up to Jeff and wrap up with Reed.
Yeah, sure. So, getting into this industry, you're really talking about performers usually. The biggest concern there, I'd say, is not realizing how quickly your content will be stolen or leaked or copied and pirated and readily available on sites worldwide. We see it all day, every day. And there's a degree of, belief in anonymity that no one's going to find out that I'm doing this if I just have a few subscribers on a fan site or something. Then all of a sudden, all their content is everywhere. Take care to protect your content, to copyright it, to learn how to enforce your copyrights, and don't get surprised when your content gets stolen. If it's a website operator or somebody else getting into the industry, think about sex trafficking and potential application of sex trafficking laws to the adult industry.
Jeff?
The good news is that from the criminal side, the risks are lower now than they ever have been, and they've never been very high. But, nobody plays Russian roulette with a gun that has 100 chambers in it. You need to know what the rules are in order to follow the rules, and there are rules. So it's worth the time and effort to find out what those are. Recently, in the margin, as I try to cross my eyes and look and read at the same time, there's been a lot of reference to COVID liability. While I can spin out a scenario where it's a catastrophic risk, I definitely can, and it kept me up awake at night for a while. The risk of COVID, I think, is not so much litigation as it is the consequence of peers getting sick, family members dying. So people are not taking COVID seriously enough because they don't want to, because of all of the myths that you can delude yourself with by saying, well, it's not going to happen to me. I don't have to wear a seatbelt. Well, you do. And if the chances are 1 in 6 or 1 in 126, if that number comes up and you or the people that you work with and care about get a serious case of COVID and is hospitalized, it's life-changing. So it's a pain in the ass. Every aspect of production is a pain in the ass with COVID. But it's so worth following the rules, the guidelines that free speech offered. These are just sensible things. People are making money following them. It's not worth taking the risk to make a little more money or have a little more convenience by not following.
Reed.
I think the biggest deepest threats are exposed by the efforts to modify Section 230. Not that I think Section 230 is going to be modified, and not that I think that the First Amendment provisions wouldn't be there to take its place, even if something catastrophic did happen to Section 230. But what the effort shows is that those who during this long period of Reaganism have declared culture war on us aren't ready to go away. And they've got an array of arguments harking back to the good old days of, as I said, curated television. They've got just a whole array of arguments of things they want to get back to. The reactionary notion that, well, America needs to be made great again, isn't going to die or isn't going to go away with the current occupant of the White House. And so I think we're going to be facing these culture war challenges for a long time, and it behooves us to really understand the political dynamic, the social and political dynamic, and to be ready to address it everywhere we see it.
Real quick, Reed, if anyone wants to get a hold of you after this panel, what is the best way for people to communicate with you?
My email address is reedley@strictscrutiny.net. Strict scrutiny, by the way, is what that Reed versus Town of Gilbert case is all about. But I'll answer what emails I get.
Thank you, Reed. Larry, how does everyone get a hold of you?
FirstAmendment.com or Larry@FirstAmendment.com email.
Jeff, before I ask you to tell everyone how to get a hold of you, it sounds too self-serving for Jeff to be begging or asking for people to donate to the Free Speech Coalition. I will do it for him because I'm a member of the Free Speech Coalition. So is Reed. So is Larry. Guys, the organization needs money. Bottom line, it doesn't function without money. Don't be afraid. I mean, whether you can donate $1, $5, $10, $15, they have memberships for every shape and caliber. Please join. Same thing, Woodhill Freedom Foundation, that is fronting all the legal bills associated with the FOSTA Assessment Challenge. Make sure you go to the Woodhill Freedom Foundation website and donate. Now, that being said, Jeff, how does everyone contact you?
Put it in the chat. It's JJD, my initials, Jeffrey J. Douglas, XXX1@gmail. Horrible email address, JJDXXX1@gmail. By the way, besides Free Speech as part of Free Speech Coalition, go to their website, our website. We're getting it better, but you'll see the work that we are doing in this wide range, including addressing, for the first time in a really profound way, the quality of life for people on set who are working on set. There's been an enormous amount of work there that's been done, as well as all of the work to keep the industry functioning during the time of COVID.
Thanks, Jeff. So guys, just real quick to kind of wrap things up. And by the way, if anyone wants to reach out to me, it's myadultattorney.com is the best way to get a hold of me. Corey at Silverstein Legal, or you can follow me on Twitter @myadultattorney. Pretty easy to get a hold of me. Real quick, I want to actually thank Jeff, Reed, and Larry. Absolute honor. I got kind of thrown in as the moderator in this, and it can be a little bit intimidating with these guys because, you know, I've been an adult entertainment lawyer for 15 years, but I'll tell you guys right now, of course, I want you all as clients and I want all of your business, but I'll tell you guys right now, with the gentleman here, with Jeff, Larry, and Reed, you're in absolutely fabulous hands. These are amazing lawyers. These are great people that I have a tremendous amount and always will have a tremendous amount of respect for. So Reed, Jeff, Larry, thank you on behalf of YNOT. And thank you all who are here watching us today. Thank you for taking the time out. You've been a great audience. Thank you for the questions. Colin, good luck with your ARP card, getting that discount at McDonald's. Thank you all so much. Everybody take care, and we'll see you guys again soon.
The next conference.
So long.
Take care. Thanks a lot, Corey.
Bye.
Bye-bye.